things down.
Well, what I need is definitely for you to send it to the other members so that they can start
Yeah,
doing their videos.
definitely.
Okay. Let me know when you're ready.
I am ready.
Okay, ladies and gentlemen and ladies and gents. We're going to try to keep this short, but there's a lot of information that we need to let you know. Coming to you straight from the belly of the so called beast. Um, Want to let everybody know that we got the links for the site up. So the actual links for the making a merchant payment is up on the site, both at SAT and at SAA. So you will see that it is a much simpler, more streamlined process, and no more people having to go down to the bank and having the bank refuse. The bank thing was only temporary. We knew that eventually that they would not appreciate people going in and making deposits. Um, I also want to thank all of you, those of you who have made contributions to myself to help with this process. It has come in handy and it has been very, 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 very much appreciated. I want to take the time to explain to all of you what's going on. The So that you'll understand what this whole mess has been about from the very beginning. In 1996, I did what I was accused of. In 1997, I ended up turning myself into a California Highway Patrol. Was he sheriff? No, he was a sheriff's officer for, I believe it was San Bernardino or Riverside County. I think, no, that was San Bernardino County in California. And very nice gentleman when we went through that process. Then I wrote out the plea agreement where I told them that I would do 1 year in, 1 year out probation, even with the so called lifetime probation standards that they had at the time. The judge decided to give me 1 year plus 1 year in. In other words, 1 year state time, 1 year county time, and lifetime probation. Told him that's not the agreement. That's not what we agreed upon. This is a first time offense and we have an agreement. They ignored me. So I spent that time researching the codes and the laws for that state, and I found something that was unique. In the state of Arizona, and you all can look this up, it's called rejection of probation. It is part of their judicial code and it's part of their statute. An individual has the right, even in whatever state you're in, you have the right to reject probation and opt to do the time instead. Since the maximum I could have done was 2 years and the medium range was 1 year, they couldn't give me any more, according to that statute, than the original 1 year. Well, the judge decided after we got the judge to recuse himself. That's the judge that I told all of you about, that I handed him a criminal complaint in his courtroom, and he didn't even realize that the criminal complaint was about him and against him. So he filed a criminal complaint in his own courtroom against himself. And that's when I told all of you that he was kicking things and yelling at people after I left the courtroom. And when they brought it to my attention, I said, "Oh, so he read it." You know, that's Judge Michael McVeigh of the Maricopa County Superior Court. The next hearing, Mr. McVeigh said, "All right, what do you want me to do?" "I just want you to recuse yourself. I don't want you on this case anymore." "All right, fine. I recuse myself from any further matters in these proceedings. The court will assign another judge." That was that situation. They assigned another judge. That hoe's name was Linda Akers. That's right, I call her a hoe because she decided to violate the law. There's a case in Arizona. It was Arizona versus Harrison. And Mr. Harrison rejected probation. And the court decided to aggravate his sentence because he rejected probation. Well, the Supreme Court of the state, it's called the Harrison decision, said that they could not aggravate it unless he had committed a different crime or a different act and there were mitigating circumstances documenting the aggravation. Well, in my case, the judge aggravated the sentence and stated exactly the same thing that the original judge stated, which made the aggravation unlawful. However, because it had the registration requirements included in the lifetime probation, and because I rejected probation, and the most they could give me was the maximum was 2 years, which they did give me, there was nothing they could do. No more registration requirements. So when I tell all of those ignorant individuals out there, I was about to use that N word with the S at the end, When I tell all those ignorant individuals out there that I am not required to, I am not lying, I'm not making it up, I am not mincing my words. However, because I did what I did, as I said in the Ohio seminar, there should have been a consequence. So I decided I would comply with the requirements of it, even though it wasn't required of me for 10 years. I didn't do it for 10 years. I did it for 15. But again, the policy is they want to keep coming at people. So they changed the law. Didn't care about them changing the law. It didn't apply to me because I wasn't required to in the state that I was in. But they changed the law. Supreme Court in Reynolds versus United States, 2012, January 23rd, decided that it doesn't apply. Well, they've been ignoring all of that. That's fine. I knew they were going to come my way because that's the only thing they could do. They could not do anything else. That is the only way they could come at me was that way. So that's why I could tell all of you in advance this is what they were going to do. When they came at me this way, I had already done the contract. Remember, I'm the president and founder. So I put myself through the process first before anybody else. My arbitration contract was written over a year ago. The only thing was I didn't send it out until I think September, October. And so everything was already in place before they did all of this. Now, throughout the whole situation, they've ignored the arbitration agreement. They don't have the right to ignore the arbitration agreement. They think they have the right, but the Supreme Court just said, and I'm going to tell it to you like it is so that all of you get it, because some of you are having a misunderstanding of this. It doesn't matter what anybody else says. Supreme Court has made it quite clear. Doesn't matter what the judge says. The judge has no say-so in matters that concern a contract and arbitration. The judge has no say-so. I'm told the IRS Form 4601B, at least I believe I'm saying the correct number, 4601. It may be 4603, but 4601B is a form that you fill out and you send to the IRS to find out the taxable status of a particular corporation. Well, individuals have been doing this with the courts to find out their taxable status. And finding out their taxable status, this is what has been held, that they are not government. Just that simple. That's the Code of Federal Regulations. But remember, the arbitration contract, the arbitration agreement contains commercial activity. That's why it's the Federal Arbitration Act, because it involves commerce. Well, anytime the government engages in a contract that involves commerce, they do so as a regular, ordinary corporation. They do not do it in their sovereign capacity. My contract is against a non-sovereign entity. My agreement is with a non-sovereign entity and with the sovereign entity. That's why it was sent to the Attorney General and all the other agencies. So, this matter is all about arbitration. This matter is all about the fact that I've rejected it and they can't do it because it's double jeopardy. I didn't say anything in court because I didn't need to. I don't need to defend myself against whatever so-called evidence they have. They need to prove, which they did not prove a single thing. The entire matter had nothing to do with anybody proving something. It was just them throwing thousands of pages of the same information, which is their little stupid knack. That's what they do. They'll put all of these papers in front of the jury, making them think they're different documents when they're just the same documents, just from a different jurisdiction, copies of the exact same documents. And when I say thousands of pages, the judge even said, oh, we have all these videos, but I'm not going to send the videos back unless they request them. Well, here's the problem. The videos were the videos from this channel. They literally were going to use my videos against me. For what reason? Don't know. But they never used any of the information on any of the videos at all. Just told the jury they had thousands of videos. Okay. Well, how do these videos relate to anything? They never said anything. Well, you should have spoke up. No, I shouldn't have spoke up. Remember, it's their job to prove beyond a reasonable doubt by a preponderance of evidence. Ladies and gentlemen, it's not their job to prove beyond a reasonable doubt. It's their job to prove that the individual is guilty. It has nothing to do with doubt. It has nothing to do with reasonable. The court will come up with that. There is no amendment in anybody's constitution that says that that's the standard. That's what they've come up. That's that stupid oral laws that they've been making from the Supreme Court and the other courts, because they make a ruling that now becomes a law. Look at the Constitution. There's only one lawmaker. Well, anyway, to put everything in a nutshell so that all of you get what's going on, yes, I still talk a lot and I love it. To put everything in a nutshell so that all of you get what's going on, the issue is arbitration. Those of you who have arbitration agreements, many of you have been trying to figure out where do we go now. We've had our arbitration had. We got our arbitration award. What do we do? You take that arbitration award, you go to the court and ask the court for confirmation. Now remember, go over the Federal Arbitration Act. Number 9 and number 10 are the ones that you will pay attention to. But number 1, number 2, number 4, number 7 are the ones that are important to you. Number 1 and number 2 says that the contract has to involve commerce. Just that simple. So the contract involves commerce, so you complied with that. Number 7 says that you have a right to have that award confirmed, and it says the reasons the arbitrator gets to make the award. Number 9 and 10 talks about the reason the award can be disqualified or vacated. Ladies and gentlemen, the courts cannot vacate your award as long as the arbitrator was honest, was not a party to the award, or they can be a party. In other words, SAA can handle an arbitration that involves SAA. There's no law against that. There's no conflict of interest. SAA can handle an arbitration involving me. What I have told people is that my job was to make sure nobody could say that there was a conspiracy or someone tried to commit fraud or something was misrepresented. So that's why I'm not an arbitrator. Okay? I don't want anybody to say I'm spearheading or leading this or leading that. Fine. You get your arbitration award confirmed. You go over those codes that I just gave you. It's the Federal Arbitration Act 9 USC. Sorry, they're watching the football game, soccer, on the television with the United States and whoever the United States is playing in FIFA or FIFA. It's actually FIFA, but we're going to say FIFA because that's the way they say it in this country called America. Well, anyway, now that you have your arbitration award, and now that you are headed to court to get that arbitration award confirmed, what do? Well, some people have been putting in the motion for motion to compel arbitration. So motion for a stay, pending the arbitration, and the courts have been denying that. Look, let me let you know so that you get it. Go back over the case law. The Supreme Court has said, and all of the courts have said, that the nation has a policy, a liberal policy favoring arbitration. So if there's a contract with arbitration involved, here's the reason why there is a policy favoring arbitration. If there is a valid contract with a valid arbitration agreement, and the Archer White versus Henry Schein case, January 8, 2019, the Supreme Court said the courts have no business interfering with such a matter, that they have no jurisdiction. Pay attention to what the Supreme Court was saying, that the courts have no say-so or jurisdiction. You can actually do a word search and look for the word no business. It says the courts have no business in determining such a matter. They have no jurisdiction. So the court can't deny a motion for stay pending arbitration. Okay? They cannot deny that. Why? Because they have no other choice. That's why there is a national policy favoring arbitration. Just type that in Google, national policy favoring arbitration, and you'll pull up all the case law. Okay, so let's say the court denies you. Don't worry about that. Go right ahead and go on through with the arbitration. Then go back into the court and say, no, sorry, the arbitrator decided the contract was valid. The arbitrator decided that the arbitration clause was valid. The arbitrator decided that the other party were in default and they did indeed violate the terms of the contract. Oh, and the arbitrator also decided that the other party was stopped from bringing any sort of collateral attack. So if you have made a judgment, or if you're planning on making a judgment in this matter, contrary to the terms of the arbitration award and the undersigned's interest, then you have just violated the Federal Arbitration Act. You see, if a court deliberately violates federal law, they are construed as having acted in bad behavior while sitting in office. So that's what you get them for, acting in bad behavior while sitting in office. Okay? But you tell them this motion is to be construed as a motion for confirmation of the award. Let's say they don't confirm your award. Do not go to a corner and cry boo-hoo, because you know I'm always here providing some sort of remedy for every single one of you. Your remedy at that point is, remember, the award and the contract are property. Pay attention. The law, the Federal Arbitration Act, says the award is binding on the parties, and that the arbitration clause is binding on the parties. So as long as the award is binding, then that's an actual debt that has been created. The other party owes you. So because it's income, but you haven't received it yet, you have to mark it down as deferred income. On your tax papers, you'll have to contact an accountant. The accountant will show you what you need to do. Don't ask me. Do not call SACOM. Do not call SAA asking, well, who do I need to contact and where do I need to? That's not for them to tell you. It's not their job. It's not part of the services they provide. The information I'm providing you is to provide some assistance, to provide some help, but that's all it's for. The information that you're getting from me right now is extra beneficial information that you can use at your leisure. But other than that, please don't think that we're under obligation to provide it. Okay. Now that you recorded it as deferred income, you also record it as a loss. After you've sent out the bill, you have to send a bill out. When do you send out the bill? You can send the bill out the moment they're in default. You don't have to wait until after you get the arbitration award. You can send the bill out after you get the default. Now, if you want to send an accurate bill, then yes, you wait until after the arbitration award. Those of you wanted to wait to tell you this, those of you who had an arbitration hearing heard, and it was back in January, well, any of you who had an arbitration and 100 days have been passed, and I wish all of you would wait for 100 days before you go get your arbitration award confirmed. Because if you wait 100 days, pay attention, go read the Federal Arbitration Act. They cannot contest your motion to confirm. They cannot contest the arbitration. They are precluded and prohibited from contesting the arbitration. Go back and read the Federal Arbitration Act. I kept telling all of you we were missing a lot of pieces to the puzzle. That was the final piece of the puzzle that we were missing, is the Federal Arbitration Act. The fact that the courts have no jurisdiction, we were trying to figure out how to keep our anuses out of the court. It is through arbitration. That's how we stay out of court. Now, when you write it off on your taxes, you do it in such a way, you report it. See, like I said in the other video, many of you received a 98 series number. Those of you who received the 98 series number, we told you we were doing that for your benefit. That's your corporation to be operating to. So assign the award to the corporation. Let the corporation file the taxes. The corporation's already pre-established, so let it file the taxes. If there are any penalties or anything, let it be absorbed through the tax credits that you're going to receive. Let that be your focus. Look, I'm giving you all kind of ideas on how to start a new company, where to do research at, how to help people. I can't do everything for you, but there's certain information I can't tell you because of the policies at our organization. SACOM is a SACOM, SAA, SICOM 911 LLC, TTOPP, they're all proprietary organizations. The information that is discussed in those organizations stays in those organizations. Really just that simple. The information I discuss with you is information that I bring to the table, but some of it I make proprietary when I bring it to their attention. Others, I tell them I'm retaining that. So, okay, now that we got that taken care of, now that we're speaking about that, we need to move to the next point. Ladies and gentlemen, after you sit up there and you write it off on your taxes, you can still go after the award. But if you write it off on your taxes, you need to understand the moment you write it off, that's your tax credit. Now, I'm going to give you something that I've only given the organization this past weekend. I had not spoken about it previously. Well, probably I spoke about it Thursday or Friday, but I do remember speaking about it in depth this past weekend. And that is, okay, writing off on the state level and the federal level gets you access to a larger sum. Now, mind you, all of this will help change the system. Why? Because they can't afford to let everybody do this, because this will balance the stupid budget. Just pay attention to what's going on here. And they can't allow you all to balance the budget this way. Because when you write it off, that debt comes off the public record. Do you understand? There's no longer any debt because you've just written it off. You just declared it a positive and a negative. You just zeroed out the account. Can't explain it to you other than that. You'll just have to understand the technicalities of accounting. Again, haven't had this conversation with anybody until now. So you guys are getting this for the first time. Okay, we got the award. We got remedies, 2 of them, for how to handle the award. The biggest one is taking the award and realizing it's property. It's your property. Eventually, companies like SATCOM and other companies SATCOM will eventually start buying up some of your awards and compensating you for the award. Now, we're going to do the same as the other companies, pennies on the dollar. There ain't no way in the world we're going to pay you the total amount of your award. We can't function that way. That's the simple. Okay, it's just that simple. We cannot tell you everything, nor can we sit up here and hold your hand through everything. Okay, now let's get back to some other information that I think those of you who have been out there, who've been paying attention, should be aware of. We have placed SAA under new management. Like Mickey Howard said, love under new management. So we just took SAA, put it under new management, and they have revamped the way they're processing things. However, many of you are trying to contact SAA directly about your particular situation. You cannot. You must notify all the parties. Any communication you send to SAA, if it's not general information about the company, you must notify all the parties of your communication. Other than that, it will be considered ex parte communication. It will not be responded to. You need to understand. They're not going to say, did you notify all the parties? Because that's a communication. So make sure that you send in some sort of notice that you've notified the other parties. It's not up to us to confirm with you whether or not you notified the other parties. It's up to you to document to us that you've notified the other parties. We take you at your word. What if somebody lies? We don't care. That's on them. They're the ones who are responsible under federal law. They're the ones who are going to get their arbitration award completely nullified, and might have penalties assigned after that, because remember, the contract is binding on both parties. So if you fail to notify all parties, but the contract says that they waive notice. You're absolutely right. The contract does say that. So I guess that was a protection for you all in advance, wasn't it? But you will have to notify SAA that you've notified all the other parties. You will have to do a proof of service in your communication. So all you have to do is say you notified all parties. That's it. Just that simple. We received, and many of you might not be aware of this, we've received at least well over 100 communications from attorneys. Saying things like we represent such and such, and we don't recognize this contract, and our client never had an agreement with you. Excuse me. So SAA has been instructed to communicate with those attorneys. I'm sorry. We don't have any documentation or record from the opposing party showing that you represent them and you've been engaged to speak on their behalf. We will need to see a power of attorney specifically referring to you, speaking on their behalf, respecting this particular issue. Until then, we cannot communicate with you. You are hereby ordered to cease and desist, and in all such communications until such has been accomplished. Make sure that that's added to the letter, that the cease and desist section, and they're to cease and desist any and all communication. Sorry, we've created the communication to send to them a while ago, but now I did not add in the cease and desist, and so they'll be given a cease and desist. Ladies and gentlemen, this is the way it works with the attorneys. The attorneys are treated the same as you. You both are parties to the agreement. This has nothing to do with the court. The rules for arbitration is not the same rules for the court. The attorney wants to come in and open his mouth, then the attorney is treated the same as the opposing party. He doesn't get to act like he's bigger and better and knows more about the law, because this has nothing to do with what he or she knows about the law. This has everything to do with the contract. If the contract says it, then the arbitrator will consider it. If the contract doesn't say it, the arbitrator is prohibited by the terms of the contract from considering it. The arbitrator gets its authority from the contract. To support that authority, that comes from the Federal Arbitration Act. So you must understand that if you don't get this, if you haven't gotten this, and yes, if you guys pay attention, since before October, I've been hammering this arbitration thing, hammering it, telling all of you how important this was. Now, some of you are starting to get it. some of you are starting to understand. Some of you are starting to say, man, they're really onto something over there. Okay? Now, what if they just ignore SAA altogether? What if they ignore all the arbitration awards issued by SAA and all of the contracts? They can't. What do you mean they can't? Well, the reason why they can't, because the moment they do that, then they lose all the other companies that have arbitration, all the other agencies that do arbitration, all the other courts that do arbitration. You see, equal protection of law. If they deny us, they have to deny them. That's what this is all about. The same as my arbitration handling in this matter. See, the judge says that they didn't recognize arbitration in criminal proceedings. Well, yes, they do. Arbitration is nothing but an alternative dispute resolution. The same as a plea agreement. Done plenty of them plea agreement things. Plea agreements are alternative dispute resolution. Arbitration is an alternative dispute resolution. You get an order from a judge saying that they're going to proceed with trial, then you've got to let the court know that it's now violating the Federal Arbitration Act, and it's prohibited from violating the federal law. It has no authority to violate federal law. As a matter of fact, the federal law takes it out of that court's jurisdiction. Go and look at all of your state federal arbitration laws. It says that the Federal Arbitration Act supersedes the State Arbitration Act. So they can't follow the state law on contract, nor can they follow the state law on arbitration. They have to go according to the federal law of arbitration, the federal law on contract. So this is so you know, because some of you guys are meeting up with these judges that want to keep that same little mill, the foreclosure mill, going. No, we're shutting the foreclosure mill down. We're just about bringing that foreclosure mill to a complete halt. If you don't think that this is now having a ripple effect on the economy, you better go back and take a look at how things have been since we started this arbitration thing. Okay? Things are not running as smooth as it was before. Now, those of you who've gotten orders from judges and you've done arbitration, the judge still went against you, bring a claim against the judge for violating the terms and conditions of the agreement as a third party, interfering with the agreement. You can do that, interfering with the agreement. They don't have the right to interfere with that agreement. That agreement was between two parties. Remember, they did not have the authority to interfere with the agreement. They cannot prove fraud. They cannot prove that the arbitrator committed fraud or misrepresented anything. They cannot prove any of the conditions that the law requires for getting rid of an arbitration. They can't do it today. They can't do it tomorrow. Why? Because the number one thing we do, the number one thing the arbitrator does, the number one thing the arbitration organizations do is make sure that they do not violate the conditions for having an arbitration overturned. Okay? So just understand that makes their orders illegal. Do you have to go to a court to get it invalidated? No, you go to an arbitrator to get it invalidated. You appeal your case to an arbitrator. Sorry, yes, it costs the same to go and appeal it with an arbitrator that it does to go and appeal it with a judge. Because don't they charge you about $500 to do an appeal? In California, it's $600. Well, the arbitration, if you go back in, it is $500. Ladies and gentlemen, some of you have been sending arbitrations that are over 75 pages. On the website, it makes it quite clear that if it's over a certain amount of pages, you'll have to pay an additional cost. From time to time, it has been overlooked, but it's starting to cause a problem. So those of you from basically now, we're going to start enforcing that policy. Between October and November of this year, we're going to start accepting deferred payment arbitration, basically where we're going to waive the payment for the individual until the completion of the arbitration, and then the person will assign that payment plus a little bit of interest to the organization from the tax credits. We'll explain all of that to you guys when the time comes. Okay, will that apply to everybody and their grandfather? Your grandfather's not got nothing to do with this, and it won't apply to everybody because everybody ain't got nothing to do with this. This is for the people who are low income. Okay, but we're only going to be doing 15 a year. That is our limit at the beginning. Let's let some of you know. Eventually, we're going to start doing arbitrations, and we're going to be deferring all of the payments. We're going to cover the cost for the arbitration for both sides, and the arbitrator will render their award, and the arbitrator will take out the amount from the award. But we're going to eventually be paying the cost for the entire arbitration. If you're thinking that they're just going to get rid of arbitration now, no. Let me tell you why they can't get rid of it. What they're trying to do is say that you can't bring a claim of arbitration if it's against one of the agencies of the United States. Ladies and gentlemen, anytime they engage in commerce, they're to be treated like any other corporation. So you're not bringing it against the agency of the United States, you're bringing it against a private corporation. Just go ahead and pay attention. Okay, so even if they did try to change it saying you can't bring it against the government, we're not bringing anything against government. None of our claims are against government. Yes, it's being sent to all capital name entities, but those are all corporations as proved by the CAFRs, and as I'm told, is the IRS Form 4601B. Not sure if I'm saying it because I'm just now getting information about that and what people have been able to do with that. So I transfer that to you all. Okay, that is the end of the discussion on that so that all of you have an update on the arbitration and what things are available for you. Within the next 2 weeks or so, I'll be moved from this location. Don't know when, don't know where, but there'll be several weeks where I will be incognito, where you guys will not be able to get in touch with me. I apologize. That's part of the process. And then I will take care of and handle the appeal and get this out of the way. If you didn't think this was a plan, those of you who are not smart enough to think for yourselves and want to believe the hype, go back, take a look at the videos, and listen to how I'm telling you this is going to happen from, July of 2017, just before I did the New York seminar. Go ahead, just go back to the video, and I told you that they were going to come after me. Why? Because I am the idiot who put out the information about the TDA and showing you guys that the account did exist and putting proof on the record that the account did exist. That was me. And they had already taken Miss Heather, the one they want to call Heather Tootsie. The court wants to take the TUCCI. Anyway, when she was going through what she went through, I've already proven to all of you that when they went after Mr. Gordon Hall, saying that he had wrote a fictitious instrument, that's a lie. They could not call it a fictitious instrument because he properly called it a money order. I've already said he can use my case in Puerto Rico, all of the money orders I put on the record. And nobody ever, and I dared them to bring a claim against me for fictitious anything. And they never did. I'm the guy who sent the Treasury and did a video showing you guys that I sent the Treasury, how many? 5 money orders over how many? 4. No, 5, sorry. 5 money orders for $680 trillion each, putting several money orders in my case NPR for hundreds of trillions of dollars, and nobody ever coming at me for fictitious or fake or anything at all. And that was in the federal court. It's still on the record today. You want to pull the record, go through it, you'll see all of those money orders there, including the was it 2 million or 4 million? It was 2 million. The $2 million money order I put on the record the day of the arraignment for Puerto Rico. That was written in pencil. Where did Marcos Lopez, the idiot, the so-called magistrate judge, said that he was noting it and filing it into the record. But Gordon Hall goes to jail for doing something similar. Ladies and gentlemen, you all know that I am the king of the so-called hour-style money orders. If anybody needs to be going to jail for money orders, it should be me. But you notice that they've never come after me. If they came after me tomorrow, I promise you I will light them up. But they are not going to. I welcome them. Sorry. Because I'm upset that they keep playing these games with people. See, I didn't say anything in this instance because there are certain things that were necessary, but if they want me to prove myself, I don't mind proving myself now because, the arbitration agreement is still in effect with each one of these matters. Getting to the last thing that we're going to talk about, there are 2 other things, but we're going to talk about the QPAC. Those of you who are interested in the QPAC, as I said, is my most potent contract that I've written. I like the fact that as I was going over the QPAC, because I have a copy of mine with me, I like the fact that when I was going over it, that in the QPAC it actually talks about the national emergency declared by Roosevelt in 1933, and then in there it says, "I'm declaring my own emergency regarding my own personal finances and how I'm going to be using emergency script." Okay, now mind you, the thinking is if the president can declare national emergency, do I not have the right to declare my own emergency? As we told you, that agreement, that trust, that contract allows and it's a special relationship trust. If you want to know how potent a special relationship trust is, just look up the word in quotations in Google, special relationship trust. Okay, and see exactly what that trust does and why it is as valuable as it is. It actually has the word special relationship trust throughout the document. Just like the conditional, no, not conditional, I keep saying equitable redemption coupon, that has an assignment in it. Now, some of you will notice that the Treasury didn't pay you $10 or $15 for the assignment. No, but what they did do is they credited your account for the exact amount of the money order that is being presented. So the value of the assignment is the fact that they paid you the credits because you're asking and ordering them to credit your account the exact same as being the issue there. So that takes care of the $10 that was done in the Chess versus Burt case out of Alabama. Just in case any of you were thinking that something was missing, it is not. And because it gives an assignment to the Treasury, it works like this. If somebody was coming after your property, you could say, "I don't own the property, the Treasury owns it." And you show them the notice of assignment. I would even be filing that notice of assignment on the county record. My job is to interfere with what they're doing because all of their junk is paperwork, people. So once you understand all of their junk is paperwork, then you just need to understand the basic fundamentals of paperwork and contract and what they file and what they don't file. Okay? Ladies and gentlemen, at this point, I'm going to have to go, so we will speak later, and I will be calling you back.